Court will come to order. All rise.
Please be seated. For the record, both Assistant State Attorneys are present, all for defense counsel and Mr. Rodgers. All right. Okay. Having reviewed the case law, thought about the arguments that were given, I think at this point the state has met its burden, and I'm denying the judgment of acquittal motion on each of the counts. Defense is ready?
Yes, sir.
Okay. We have all the jurors? State's ready?
Yes.
Okay.
Maybe approach prior to the juror.
Okay, don't bring them out. Okay. Both sides are ready.
Yes, sir.
State. Mr. Rodgers, sir, you do understand whether or not you testify here today is a decision only you can make. Do you understand that?
Yes, sir.
You understand your lawyers can only give you advice on whether or not they think you should or should not take the stand. Do you understand that?
Yes, sir.
Understanding that, sir, have you had enough time to talk to your lawyers about whether or not you should or should not testify?
Yes, sir.
Do you need any more time?
No, sir.
What would you like to do?
I do not wish to take the stand, sir.
Yes, sir. Okay. Bring the jurors out. You don't have to retrieve your notepads. You don't have to worry about retrieving your notepads at this time. Please be seated. I'll ask our jurors again, did you follow my instructions, not talk about the case among yourselves or with anybody else, or look up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. Defense?
At this time, the defense will rest.
The defense having rested, as well as the state, there's matters we have to take care of outside of your presence. I'm going to instruct you, even at this point, even though both sides have rested, do not discuss the case among yourselves or look up any of the people or places involved, and we'll be with you as soon as we can. Thank you. Please be seated. Yes, sir. Motions.
Yes, sir.
Good morning, Your Honor.
Good morning.
On behalf of Mr. Rodgers,
And we are at the point of the trial where the state has rested, the defense has rested, and we ask the court to consider the JOA arguments based on the closing of all evidence. And what I would like to do is refer to my JOA argument after the state has rested. We're relying on the same case law. I could read word for word what I said then, but I think the court having the cases, the court understands what our opinion is, where we believe the JOA should be granted. I also want to talk a little bit this time about the state not overcoming every reasonable hypothesis of innocence. In this case, it has become quite clear that there is no evidence that puts Jimmy Ray Rodgers in that house other than the word of Curtis Wayne Wright. And we know that Curtis Wayne Wright's word is not worth the proffer agreement that the state gave him. He had great motive to listen to the story that was fed to him by the detectives. They allowed him to lie to them during his first proffers. They got played by Curtis Wayne Wright. That's what the evidence has shown. His word is not trustworthy because his story makes no sense. Right down to where he says he took a $600 down payment for a $100,000 hit and asks us to believe that in a hit that the check would come from the bank account of the victim to the hitman for $600. And we know that he's not telling the truth because we also know that Curtis Wayne Wright would go $100 a month receiving money from Dr. Sievers' business account, and he would get paid sometimes once every 6 months. We know Curtis Wayne Wright had been telling everybody he was going down to Florida on business. We know Curtis Wayne Wright says he can't drive and he needed help to drive. The state presented a lot of effort, a lot of time, a lot of experts to point out the fact that a car drove from Missouri to Florida and Florida back to Missouri. If this was as Curtis Wayne Wright says, how is it that somebody who is such an expert in computers, somebody who doesn't want to talk on phones because they're being monitored, is running with a Garmin that is going to leave a breadcrumb like Hansel and Gretel to a scene and then away from a scene? It makes absolutely no sense. When, if you listen to what Mr. Wright is saying, that I then realized that Mr. Rodgers had a phone, he then watches him plug it into the Garmin. That's indicative of there was no plan of any crime going from Missouri to Florida. Mr. Curtis Wayne Wright, when he's talking about, well, I'm telling everybody I'm going down there for business, but when allegedly Mark Sievers says, I need it done this weekend, does he tell anyone, no, I'm not going to where I am going to allegedly make a hit? No, he says, I just stopped telling people I was going to Florida. It makes no sense. For every bit of evidence that the state presented about the phones and the tower dumps and the pinging, none of it actually puts Jimmy Ray Rodgers in the house on Jarvis Street. We know this because if we read the top of the AT&T sheets, which was made part of as evidence, it's do not rely on this. I can just have the sheet please. I want to make sure I get it on the record correctly.
Yes, sir.
Thank you. Historical position location information. The results provided are AT&T's best estimate of the location of the target number. Please exercise caution in using these records for investigative purposes, as location data is sourced from various databases which may cause location results to be less than exact. based on the state's own evidence, they cannot use the phone data to say Mr. Rodgers was ever in that house. The best they can say is he was in the location of the house. That's all they can do. And if you look at everything that Curtis Wainwright says, and how, where now he's talking about, well, I wasn't a hitman, they do it for money, but, well, geez, maybe I'm just not a good hitman, and little things. He talks about, well, the plan was to go down and make it an accident. But then Jimmy's the door open. None of this makes any sense, Your Honor. And it's very rare that we get to sit so close to evil. And that's what Curtis Wainwright is. He's evil. He is the only person that ever claims that Jimmy Ray Wright was in that house. Or, I'm sorry, Jimmy Ray Rodgers, thank you. It makes no sense that Mr. Rodgers was ever in that house. There's no physical evidence that is taken from that house that links Mr. Rodgers. It is consistent with never being in the house. What we do have that's consistent evidence is that Dr. Sievers was hit with a hammer. They have the hammer. Dr. Coyne says it's consistent with one weapon and with one assailant. We know Curtis Wainwright is that assailant because he says, that's the hammer I used. And it's only after he is now starting to be questioned, he starts playing the police as to what they need as information, and when they feed him the story, when they bring up Mr. Rodgers' name, that's the only time he starts bringing it up. You know, evil will do anything when it's caught, and that's Mr. Curtis Wainwright. Evil will look into the eyes of a murder victim's children at their mother's funeral and will hug them, because that's the extent he's going to go to try and throw everybody else under the bus, when the only reason that Mr. Rodgers was in Florida was because Curtis Wainwright was going down there on business and was asked to help drive. Dr. Coyne very specifically said that, well, a hammer is not the normal tool. A hammer is something that's usually there and is picked up, and in his experience, not only here in the 21st District, but over at Miami-Dade as well, where he's done hammer murders before, he talks about it's usually something that is so emotional, and it is usually somebody who knows the person. They're just that angry at that person. No evidence whatsoever that the state can point to puts Mr. Rodgers in that house. Because there is a reasonable hypothesis of innocence, we ask that the JOA be granted, once again referring to all the case law that I have previously presented. Thank you.
Yes, sir. State.
Your Honor, this is not a circumstantial case. This is a case with an eyewitness as well as a statement, a confession to Taylor Showmaker. It is to the jury, the fact finder, to determine the credibility to give to each witness and to the evidence. I could respond to each statement made by counsel, but I think that I will just make a couple of comments. For instance, as to the injuries, Dr. Coyne said it could be one hammer or multiple hammers. It could be one assailant or multiple assailants. So the evidence presented by the state does not contradict the statement of Curtis Wainwright that there was a multiple assailants. The evidence is sufficient for the state to proceed further, for this case to go to the jury, and the state asks that the court deny the motion for judgment of acquittal. Second, please.
Okay. Anything further?
Yes. As far as Taylor Showmaker, the Lee County Sheriff's Department has paid her at this point approximately $19,000. Somebody in the media has flown her out to California. When asked, what is Mr. Rodgers' nickname? And then the state brings it up, what is his nickname? Taylor Showmaker has to admit that when she swore to tell the truth at a deposition, she said, I'd never heard anybody call him that. She will say what she needs to say because not only is she taking $19,000 from the Lee County Sheriff's Office, not only has she been flown out to California by the media, and it looks like there's going to be more of that, but there was also talk of a $50,000 reward. The state forgets that when Ms. Fitzgeorge was talking to Ms. Showmaker, and keep in mind the state was laying a lot of credence into what was in the cooler. Ms. Showmaker, on the stand under oath, said, I never looked into the cooler. She was very adamant about that. The state then had to say, but what'd you tell us before? What'd you say in a statement? Once again, this is the Lee County Sheriff's Department feeding the state's main witnesses what they need to say in order to make a case. They're not trustworthy, and when you rely on the evidence as it was presented, the JOA should be granted because the reasonable hypothesis is Mr. Rodgers was never in that house.
Okay. The exception of the admissions to Ms. Showmaker and Mr. Wright and the tacit admission to the law enforcement officer, it's a circumstantial case. However, the credibility of those witnesses, that's an issue to be resolved by the jury. Motion for judgment of acquittal denied.